Nashville or Chicago or Brussels, they're less important. And so we need to understand that we can, in a way, discount them as far as our attention spans go, and that perhaps we should give our attention to things that are happening here, and that we should think lococentrically. We should think perhaps globally, and act in terms of a lococentric ethic. And this is David Toulis at 92.7 here, Media Radio, and we argue for local economy and the free market. One thing that we have given a great deal of attention to is the idea of checkpoints and roadblocks. They are unconstitutional. They remain unconstitutional, but the High Court, citing the high monarchical doctrine of compelling state interest, maintains that they are lawful, and they are doing so in a new case run by a defendant here in Chattanooga, a man named Robert Franklin, who appealed and had the benefit of the work of the law firm of Jerry Summers and the firm Summers, Ruffalo, and Rogers. And I have with me here one of the younger attorneys at the firm, Ben McGowan. And we want to find out, Ben, about this case. Where in the older cases, the Hicks case, the Downey case, where are the court's ideas firm on those? And are there any changes in what effectively has become a law? Now, here in Tennessee, we have the legislature which writes law, but when the court agrees to be illegal, when the court agrees to reject the Constitution and create policy, it has, in its opinion, the effect of creating a law. And those opinions, the ones I mentioned, are law, effectively, practically, though not constitutionally. And those laws become general orders that run highway patrols and corporation departments such as Red Bank Police, who were involved in state of Tennessee versus Robert A. Franklin. So if you could, Ben, tell my listener what, in a nutshell, happened in this ruling.
Absolutely. Well, David, thank you very much for having us here today. And I'm sorry Mr. Summers couldn't be here as well. I wanted to first by pointing out that you tap in directly to the prevailing law in this area. The Downey case is the 1997 Tennessee Supreme Court case that lays out balancing factors that are pertinent to whether a roadblock is constitutional or not. You know, the problem that we have from there is these factors exist, but as you point out, they're all subject to judicial review. They're all subject to different valuations on those principles. The first principle in laid out in Downey in the balancing test, but I should start by saying this to your listeners, and as obviously you know, we start with the premise in this state and in this country, frankly, that warrantless seizures are unconstitutional, that they are presumed to be unreasonable. And under the Fourth Amendment and our Article 1, Section 7, these are basic core principles. And so that the burden becomes on the state to establish a reason that the search or the seizure in this case is permissible. And that the lip service that is,
though non-particular, it is permissible. And so how do we rationalize that?
Well, we rationalize that in a lot of ways. I mean, you can see from the case law that, you know, in a way, it's one of these where the exceptions have begun to overtake or subsume the rule. And what we have in a situation like this is something that even goes beyond the traditional notions of reasonable suspicion and probable cause that may justify a warrantless search under certain circumstances. Here we have a checkpoint. Here we have a departure even from that standard, which is that the checkpoint is created for the sole purpose of police, law enforcement in some capacity, interacting with civilian citizens who are suspicionless, who are without any reason to believe they're involved in any misconduct whatsoever. They're going about their daily business. And the checkpoint doctrine has, well, I don't want to call it a doctrine. It really isn't, in effect, a doctrine, but the idea has become that this is a socially acceptable or acceptable, what's called a community caretaking function, and something that law enforcement can then therefore engage in, subject to some rules that we can get into if you're interested.
Right. Yeah, we do want to get into the rules. Now, just thanks, Ben McGowan, for opening up the topic. But we're talking here about a checkpoint that occurred on the Red Bank side of the little tunnel that goes goes
Stringer's Ridge,
the Stringer's Ridge Tunnel on Cherokee Avenue. It was down the Red Bank side, and it was at a road. Now, so explain just briefly what the facts are.
Sure, and it's helpful to kind of envision the area for your listeners. This is if you're going out of town northbound on Cherokee Boulevard, and you pass Nicky's restaurant on the right, the Stringer Ridge Tunnel follows right thereafter, and the placement of that is important. Once you come out of the tunnel there, you're at a slight bend in the road, a slight bend to the left in the road, and there is you're entering the city of Red Bank along Dayton Boulevard. What had happened was back on June 15th of 2012 is it was during Riverbend, and the State Highway Patrol determined that they wanted to establish a checkpoint to ascertain whether people were complying with DUI laws. And so what they did was they had previously come up with a list of permissible locations. The list was in our opinion quite outdated, and they then sought permission to have a checkpoint established at that juncture. The idea being that when you would come out of the tunnel, you would see for the first time the blue lights, the cars, and then be directed into the checkpoint,
into the trap.
In effect, certainly.
In this case, it was a trap because there was no escape. There was no avenue for escape, which Jerry Summers and you pointed out, right? There was no escape road.
And in fairness, that was subject to some dispute. We think the facts were very clear that though the state maintained the position that Ashmore Avenue, which is a road to the right, was an area in which someone could decide to not consent to be stopped under these circumstances.
And in other words, to go around it.
That is correct. But our position was, and we believe the evidence was, that the police were not only standing in that intersection and directing people into the checkpoint, but also that there was a show of authority. And that's the thing to remember here, that when we're talking about checkpoints, part of the fallacy that's developed around them is that they are consensual in some regard, because people can opt out and people can drive through and people cannot open their windows.
And why did the earlier cases make that important? Why did the earlier court say we need to make it so that you can escape it? Why is that valuable?
Well, I think because it is such a departure from our established notions of the sanctity of individual privacy and individual rights not to be tampered with when we're engaging in perfectly lawful conduct. And so, in order to have a justification, part of the notion behind this was that you should be able to elect not to participate. But in effect, the way these things are established, and particularly in this case, which was the checkpoint was concealed after a tunnel, and really you were in the funnel and there was no getting out at that point, is that once you see the lights and the police and they're in uniform, and most rational people are going to
and the warning sign of checkpoint ahead doesn't tell you that this is the escape, especially if they're standing right there, right?
That's exactly
checkpoint
right.
Ahead. When ordinarily I've been through, I've witnessed these. The warning of checkpoint ahead telling you that you can escape is usually right at the intersection where the bypass road is, but here it was not possible to see it that way, given the context.
I think that's exactly right, David. You got it, because there were no signs on the southbound side of the tunnel. So once you were in the tunnel, and moving forward and came out, there was no way then to opt out, and that was, I think, important in the court's decision in overturning the conviction, was to say, look, they questioned the wisdom of ever using tunnels to conceal checkpoints, because one of the operational principles that the court has adhered to is the checkpoint set up in such a way that it provides for safe advance notice to citizens.
All right, the whole idea of notice is very important. We're talking with Ben McGowan of the Summers, Ruffalo, and Rogers law firm here in Chattanooga, and they have overturned a conviction of a man named Robert Franklin, a businessman here in Chattanooga. The checkpoint was illegal and unconstitutional, and notice played another part in this decision, in this 50-page ruling, Ben, about 16 pages of which is on jury selection. It's kind of a waste of time to read that, but the main elements are in the first 34 pages or so. And Notice on publication. Why? What is the so-called rule on publication from the earlier decisions? What is the purpose of publication? And was there sufficient publication according to the earlier opinions is required of these departments, Red Bank and the Highway Patrol?
Okay, exactly. So the way the court has justified these roadblocks in the past is to say that there is they're expecting certain operational procedures to be in place, and there is a general order. It's called General Order, I believe it's 410-01 of the Tennessee Highway Patrol, that lays out in considerable detail what has to be done in order to have a valid checkpoint. And the purpose there is to reduce the supervisory discretion of the officers on the scene. And the example...
You mean to increase the supervisory discretion and reduce the discretion on the scene, right?
Well,
more supervision, less discretion.
Well, right? True. That's exactly right. That's a better way to put it. So in effect, what you want is the officers on the scene who are acting according to principles that were developed out of the context of the actual stop. And so what you have is rules about how many cars, the order in which cars are stopped. Are all cars stopped going in both directions? Is each car stopped, or is there a predetermined order, that every third car, every second car, whatever it be, that decision is made in advance? So you cut down on the discretion of the officer on the scene saying, hey, these guys look
Why is that
fishy.
Important for my listener?
Sure, these guys look pretty fishy here in this car. Let's go ahead and pull them over, making ad hoc determinations on the scene that then permit them to exercise discretion of who they're going to stop and why they're going to stop them. The other issue, and it was a major one in this case, and I think that's what you're getting to, is this question of notice. One of the justifications for sobriety checkpoints in particular is that the principle that they're trying to get at is the gravity of the public concern of drunk driving. And so in order, and that the purpose of checkpoints should be to discourage, to act as a deterrent for drunk driving. Accordingly, the order requires that the order relied upon by the Tennessee Highway Patrol relies upon the prior notice has to be done by way of a press release. And the order is extremely specific. It says that it lays out the manner in which the press needs to be notified. There's a period that the order, that the location of the checkpoint, or at least the county and the day of the checkpoint, needs to be publicized.
Well, that's not, go ahead.
It needs to be done at least 2 weeks in advance of the checkpoint itself, and it has to be distributed to outlets. You were going to say that's not very specific.
Well, no, that's not very specific. Saying even to say we have a checkpoint on this day on Cherokee Boulevard is inadequate notice. It doesn't to say we're going to have a board meeting tonight on Market Street is not notice about a board meeting. So it has to be the location and the time. And these jurisdictions, I think, are very, very careless about specificity. Even the Highway Patrol. I've asked the PR guy from the Highway Patrol, you are wrong to not say where on Suck Creek Road this roadblock is going to be, because they seem to have them there a great deal. That's a very long road, and my listener needs to have notice about what intersection to avoid if he wants to avoid being offended by your roadblock.
And I think that's the right way a citizen should be looking at it. I think the way law enforcement tends to look at it is that we're sending out notice merely for the purpose of deterring drunk driving, and therefore we want you to be surprised. We want you to be, we want you to be in fear, in fear to some degree. I don't think they would ever come out and say that. In fact, that would be anathema to what they espouse to be the principles behind the checkpoint. In this case, what was uncontroverted at the trial court level in the motion to suppress, in
Judge Poole's court, Don Poole,
it was that there was absolutely no public notice given according to the order. It was a huge factor in the Court of Appeals determination of the unconstitutionality of this, because for the reasons cited, that the state, to the degree they wanted to rely on the fact that deterrence was a factor in this, as was very succinctly put by Mr. Summers in the brief, there's proof that there was a zero deterrence, because without notice, there could be no deterrence of anyone drunk driving on that evening.
And we're talking about Ben McGowan of the Summers Law Firm. Notice being a 1-inch deep classified ad in the Chattanooga Time Free Press, that fulfills the requirement. I know Saudi Daisy, which is pretty good with these things, fulfills its duty to have that notice. And again, I guess it's just a principle that there has to be some kind of notification. And if I'm told about it, well, I'm going to noise it abroad as a member of the press. The state, I think, counts on that. Though I think officers in the field and probably police managers want that element of surprise. My job would be to noise it abroad, serving that state interest of notification and notice, again, with the deterrent effect understood to be there. And why, though, in this case, did Red Bank or the THP lower officer not do that, knowing the rules from the court in its earlier decisions, Ben McGowan?
Frankly, we never got a particularly effective explanation of that. The site supervisor indicated that he had checked off there's a formula, there's a form that they use that has boxes, checklist that uses boxes to show what has been done. It was checked off that public notification was done, and the order is quite clear that it's the site supervisor's responsibility to ensure that notification has been given and that the checkpoint should not be conducted without a positive confirmation of that. Notwithstanding, that box was checked off, and there was no notification ever given. We never did.
Yeah, assumptions were made by the supervisor about what the lower man had done.
Well, what the upper management had done, it would have been the responsibility both. But to the extent that was just an oversight is in question, because there's another important component of that order that requires the THP, the Tennessee Highway Patrol, to also notify the district attorney of Hamilton County, and also all law enforcement officers in the jurisdiction, every law enforcement organization in the jurisdiction. We have folks entering the tunnel on the Stringers Ridge side from Chattanooga. They would be within the environs of Chattanooga. We have Red Bank on the other side. We know Red Bank was involved in this checkpoint, but Chattanooga was not. There's no indication that they were informed. There's no indication that Neil Pinkston's office was informed. And so it does certainly raise a concern that it wasn't mere sloppiness about the failure to public notify the press and the public via the press.
May have been a little bad faith, perhaps. But the ruling doesn't indicate that was part of it. We're calling, call us at 800-8949 if you have a question, 800-8949. Ben McGowan, you're an attorney. In a nutshell, what should my listener, let's give us some useful information here. You're an attorney. Boil down what these rulings tell the listener about evaluating the legality of his next checkpoint if he is, in God's providence, sort of ordained to go through one. What are the things to look for to indicate whether this is not right, this is illegal?
Well, obviously, I mean, there's a legality side of this, and there's also a practicality side of this, and obviously, we're not in a position to give people general legal advice about how to conduct themselves. But what I think at the bare minimum, people need to be aware of what is occurring, and to be certainly conscious, so that should something occur in the context of that checkpoint, that they can go back and look at it and say, hey, listen, this wasn't kosher, this wasn't right, and this is how it's conducted. So they can sit down with somebody who can advise them their rights. But
that means run their phones as cameras.
And that is
make a record.
That is certainly an option. This is let's face it, that the state, taken at face value, agrees with us that these are interactions that are largely consensual, that they are involve the participation of the person being stopped, involve the participation of the citizen. And so there is no limitation on your ability to record. We live in a single party consent state with respect to recordings. And so the idea of recording that interaction is certainly a viable option.
And we here would encourage you to do so. You report and the world decides here at Nuke Radio 92.7 FM and 95.3 FM HD4. Make a record of it. And I always say make an affidavit immediately after any encounter with an official that is negative to you. And so again, there has to be notice. There has to be non-individuated stopping of cars. If there's a traffic buildup, and they let people through, that's allowed by the.
Sure. Do you notice rulings that the car in front of you that you're watching, is every second one getting stopped, or are they seeming to randomly stop certain cars and not others? One of the other points in this case in particular was that the checkpoint was set up for the purpose. The checkpoint was set up for the purpose of having field sobriety checks. But the court pointed out in its opinion that they were actually looking at people's license plates to determine if license plates were expired, which was the reason Mr. Franklin was stopped in this case. It was a purpose having nothing to do with the established reason for the checkpoint. It showed discretion being exercised by the officers at the scene that was not permissible under the order and was not acceptable under the establishment of this particular checkpoint.
Ben McGowan, if my listener has a legal question or a problem, how can you reach you?
Please call our office. The office number is 423-265-2385. Ask for Jerry Summers, Ben McGowan, or Mario Schock. We'd be happy to work with you.
This is David Toulis, and on Thursday, I'll be at the Starbucks at 10 North on North Shore. We have a terrific show, the Gridiron Gang Show, every Thursday with Keon Rose and Nick LaFew and others broadcasting live. The topic is high school football, so stop by and enjoy the special drink. They're great specials at the local Starbucks at 10 North. That's every Thursday. Every Thursday, start a new habit of the Gridiron Gang Show live at Starbucks. David Toulis, Ben McGowan, thanks. Thank you.
3, 2, 1.
Chattanooga Radio, Digital FM 95.3 HD4, 92.7 FM's news now.
Police are on the hunt for a man who walked into the Boost Mobile store on Wilcox demanding money and phones from the clerk at gunpoint. The suspect is described as a man about 6 foot tall, toting a black semi-automatic handgun. If you have information, you can leave an anonymous tip with the CPD. Stephen Reed pled guilty to a triple stabbing that happened back in 2016. Cops say Crystal Canino and Crystal McCarter both died from multiple punctures with a knife. Another victim, Sewell Beck, survived. Reed sentenced to 52 years in prison for the brutal slayings. And a man has been arrested in the Hot Water Road killing. Tracy Bowman was taken in yesterday afternoon. Deputies say he shot and slaughtered 69-year-old Roger Kelly on Hot Water Road in Saudi Daisy. The charges indicate it was a botched robbery. Bowman was arrested in Bradley County, booked into the Hamilton County Jail, charged with criminal homicide and especially aggravated robbery. Val St. John for Nuga Radio, News Talk 92.7, Action News now.
Chattanooga weather.
Expect lots of sunshine and more great-looking weather out there through your afternoon. Highs settling into the lower to middle 80s. Tonight, clear, comfortable again. Lows 63 to 65. For your weekend, a little warmer, but still looking dry with some sunshine through Sunday. Highs into the upper 80s. For lunch or dinner, come to Guthrie's, home with the original golden fried delicious chicken finger with their special world-famous sauce. Open daily. Locations in Trenton, Signal Mountain, and Ringgold. Go get Guthrie's. It's always good. And I'm Source E12 Chief Meteorologist Patrick Ford.
Nuga Radio 92.7.
Join Nuga Radio and the Gridiron Gang live from 7 to 9 at Starbucks at 10 North on the North Shore. We're talking all things high school football. There's a specialty brew or refresher weekly inspired by the game of the week. Sweet treats, extended hours all season long, and we're pet friendly. Portions of all proceeds support local schools and educational scholarships as well as after-school programs. It's football time in Tennessee. Join us every Thursday live from 7 to 9 at Starbucks, 10 North, your North Shore neighborhood living room.
My ex recently hacked my email and my social media, and it really caused me some problems. I changed all my passwords, which helped, but I'm still getting trolled, maybe even stalked. I know it's him. I just can't prove it.
My business, well, it's been broken into twice already. I've got cameras, but that only helps after the fact. I'd rather prevent it from